better. Good morning. Might I just introduce two of our Thai lawyers from my firm who have come along here today in case there are any Thai citizens here who don't have a really good grasp of English. They're happy to answer any questions later in the morning. I'd introduce you first to Noon. Noon, if you wouldn't mind standing up. Noon's one of our more experienced and senior lawyers. Despite her very youthful looks, she's got a few years practice in the law, and she does more of the more difficult stuff, partly with me and partly with some of our other lawyers. We also have Mix, who deals with running most of the estates within the firm. He does the day-to-day work relating to them. So if there's any Thais here who want to have a talk, have any questions, they're happy to speak to you later in the morning. In terms of my situation, I'm an Australian lawyer. I'm not a Thai lawyer, and foreigners can't be lawyers in Thailand. I've had 45 years of practice in the law. I spent the first half, or little more than half, of my working life in an Australian regional firm. When I first joined the firm in the 1970s, there were 5 members of the firm, 5 people worked there. When I left towards the end of the century, we had a staff of 40 and 12 lawyers. So it got fairly big over a fairly short period of time. During that period, we decided we couldn't do everything, so we decided we ought to get into specialist areas where we'd have greater expertise. As I was an article clerk with what was then called a divorce firm when I was studying law, I decided to go back. I was still doing a fair bit of family law, but I decided to go back and do it full on and join the New South Wales Law Society Family Law Committee. Ultimately, I moved the motion that set up specialist accreditation in New South Wales, and for 20 years I was on the Family Law Specialist Accreditation Committee, and for 10 years chaired that. And when I retired about 24 years ago, I came to Thailand, and I've been here working with Lana lawyers for about 10 years. When I was in Young, the country firm I was with, the firm was established in 1859. We had in our office a walk-in, like a bank vault, that had 3 walls, all of which was roof to floor, stacked with security documents, principally wills. So we had a very, very large wills and estates practice, and we got a lot of work in that area. The local radio stations used to publish the death notices, the funeral notices, in the morning, and my probate partner would go straight to our index and he'd say, "Oh, we got 4 out of 5 today." But that's the level of sort of work we had in probates and estates. When I went to Sydney, all of the other lawyers in the firm, all of the other partners were specialist family lawyers, and that's all they'd ever done. I was the only generalist, apart from having specialist skills. I did all the wills in the firm. When you're dealing with the client who's going through a divorce, separation doesn't revoke a will, so your will still stands and may be in favour of your partner. Most clients wanted to change that until they'd resolved the family law dispute. So I had a lot of experience in doing wills there. So we might lead on to what we're doing today. What's a will? In legal terms, a will is called a testamentary disposition. Testamentary meaning related to death, disposition, disposing of. So it's a document, almost always a document, that disposes of your property and assets at the time of your death. It doesn't come into play until the actual moment of your death, and then it comes into operation. Do you need a will in Thailand? Well, that depends. If you have no assets, you're probably in Thailand, and you've got a will from the country you came from, you probably don't need a will in Thailand. Your will in wherever you come from probably still applies in Thailand, but you need to look at each case separately and have a look at the will. There is provision in the Thai Conflict of Laws Act that says if you that a foreigner can make a will in Thailand according to Thai law, or can make a will in accordance with the law of his country of his own country. So a foreign will can be valid in Thailand. So if you don't have any assets other than maybe a bit of furniture and some personal effects, you probably don't need a will in Thailand. When do you need a will in Thailand? Well, If you've got a bank account, that's a good start. Most expats are usually on a retirement visa or a marriage visa, which means they probably have either at least 800 or 400,000 baht in the bank to support their visa. If a foreigner dies in Thailand, if you go to the bank, here's the death certificate, here's the will, they'll say, go and get a court order. The Thai banks regard a death of a foreigner in Thailand as a windfall. They think you won't go to the trouble of getting the money. Now, in Australian dollars, 800,000 baht is in the order of close to $40,000, so it's certainly worth proceeding with an application for probate, or what in Western countries is called probate. We'll come to that process later. But yes, if you've even got a bank account, if you own a car, if you own a condo, or you have other financial assets, you do probably need a will in Thailand. Each case is different, but the short answer is yes, you probably need a will. What else have we got?
Can you prepare your own will here in Thailand?
You can. I had a look on the internet this morning for sites about wills and estates, and I found about 5 factual errors. When you look on the internet, you'll find the right answer, but it could be buried amongst 99 answers that are wrong. So it's a risky process. Back in the day in Australia, newsagents sold what was called will kits in the 70s and partly into the 80s. They sort of disappeared when the internet came into play. But and there was nothing wrong with the will kits. They'd have a draft will and you filled in the blanks and it had text telling you what you should or shouldn't do. Let me tell you, I have never ever seen a newsagent will that didn't have a problem. The most common problem was there was no residuary estate. It might say, I give my house to my wife, I give my car to my nephew, etc., etc., and then would forget about one. There might be other assets that haven't been included, or 2. They might not have those assets at the time the will takes effect. The will takes effect at the date of death, not the date you make the will. And I see here in wills prepared by other lawyers here, probably 8 times out of 10 it will start with a very lengthy list of assets, and sometimes it doesn't have a residuary clause. A residuary clause is a clause that says, I give the rest and residue of my estate as to 20% to A, 20% to B, and 60% to C. Now that will pick up all assets, and that's one of the problems I see, I won't say often, but I see regularly in Thai wills that have been drafted here. There are some of the information that I saw on the internet this morning. You have to start with a list of assets in your will. Wrong. That's simply wrong. And indeed, you might not own those assets at the time of your death. I give my red Mercedes to Bill, and at the time of death I have a blue Mercedes. The gift of the red Mercedes fails, and there's a partial intestacy if I haven't got a residuary clause in relation to the blue Mercedes. So yes, there's lots of mistakes that you can make. I got a will made in Thailand last week, and it was a woman who died at McCain Hospital. Heather will be speaking next week from there, and that place is really good. Dock Cow Gardens, for people who are getting close to death, is they give really good care of people. But this
for a quick second. For the rest of us, can you define your term intestacy?
Intestacy is when you die without a will. A partial intestacy is where your will doesn't cover all of your assets. So if you only list certain items of property and you have other items at the time of your death, those assets will be subject to a partial intestacy. They will pass to whoever is entitled to your estate if you don't have a will. We'll come to that later. So yes, you can do your own will, but be very careful. This will that I got last week, a lady, a US citizen, died at Dock Cow Gardens last year. She had a 2-page will. It was drafted in sort of quasi-legal language. Someone had picked it up here and there, and it was generally badly drafted, but it was clear what the intent was. The will at the end of the first page said, I give the residue of my estate as to 50 out of 100 shares to my husband and as to 50 out of 100 shares to my daughter. The intention was clear. It was half and half. Where it did have a problem, what happened, which was a clear possibility, what happened if the husband died before the testator, before the will maker? There would be a partial intestacy as to one half of the assets. If the clause had been changed, I give the whole of I give the rest and residue of my estate in equal shares to such of my husband, to such of my husband and my daughter as shall survive me, and if more than one in equal shares. Now that picks up, if one of them dies, if the husband dies, then the whole of the estate goes to the daughter. So there was a real problem there with the drafting. We then went to the second page. It was signed at the base of the first page by the testator. We went to the second page. The only thing on the second page was the signatures of the two witnesses. One looked to be the signature of the husband. And I wrote to the daughter and said, can you tell me who the attesting witnesses are? I have a feeling one is your father. And she wrote back and said, yeah, he did sign it. A beneficiary can't witness a will. That's against the law around the world. But she wrote back to me and said, Singapore's different. A spouse can witness a will. Well, that was wrong. I checked the law in Singapore. Not only can't a spouse witness a will, but a partner of the spouse can't either. And in any event, because the will maker died in Thailand and had her principal residence in Thailand at the time of her death, the estate was governed under Thai law. Thai law says that a beneficiary can't witness a will. So the will, in a number of respects, had serious faults. They're the risks you run. It might be fine. You don't pick up these relatively small issues that need to be addressed to give the will as long a life as possible. That is, you don't have to keep going back to the lawyer to change it every time there's a change in assets or a change in the family. You give it as much life as possible so that, again, you don't have to keep going back to the lawyer to get a new will. So you can do your own will. Good luck, is what I say.
So let's talk for a minute about the probably fairly large number of us who may have a will in our previous country.
Yep.
And so some specific questions.
Okay.
So what value is that will, number one? Number two, what do we have to be careful of if we do a Thai will so as not to invalidate the will in our home country?
Okay, I always ask a client if they have an existing will in their own country, and if so, I ask them to let me have a copy so I can have a look at it. I don't charge for that. I will tell them whether it covers their assets in Thailand and whether it's appropriate to have a new will here. There are a number of reasons why you might have wills in different jurisdictions. If you have significant assets that warrant an application to the court on your death, it's probably a good idea to have a separate will here. You should, if you're making a will in Thailand, normally you could make it to cover assets wherever. The general principle is every will revokes all former wills, unless the will says otherwise. So typically, a will in Thailand might say, this will is made in respect of my assets in the Kingdom of Thailand only. I revoke all former wills in respect of Thai assets, but not wills made in respect of assets I hold elsewhere. Now that preserves your will in America or wherever it might be, and the will you make here will only cover Thai assets if that's what you wanted to do. There's some countries where there's particularly good reasons to have separate wills. UK, the inheritance tax, it's a real danger. It's very, very complex. Whilst you might be domiciled in Thailand if you die here and have your principal residence here, there are a number of deeming provisions as to domicile and residence in the UK, which may mean assets here may be picked up and be inheritance tax charged in the UK. So it's a good idea to have separate wills so that the UK don't see Thai assets at all.
Let's stop for a quick second here to emphasize a point. a will almost always, as Joe said, invalidates any prior wills. So you want to make sure that you know, again, what you're trying to accomplish. And it is not a problem to create a will here in Thailand and to specifically say, this does not impact my will in Australia or wherever. But you have to do it, right? You have to make sure, again, that you follow the rules, because the unintended consequence would be great. I've created a will in Thailand, and in the process, unknowingly, I invalidated my will in my home country, which if I didn't want to do that, could be a big problem. So again, just pay attention. It's not complicated, but you do have to pay attention to it.
I had a friend of mine last year, and we did a will for him covering his assets in Thailand. And I said to him, he said, I'm going to review my will in the US. I'm going over to the US shortly. He came back, I said, make sure you don't revoke the Thai will. Tell your lawyer. He came back and I said, did you tell your lawyer not to revoke the Thai will? He said, yes. I said, can I have a look at it? And I said, you've revoked your Thai will. A lawyer who doesn't do international work often doesn't appreciate the nuances of that sort of thing. Anyway, there was no problem. We simply printed out the will again, put a new date on it, and he signed it, and problem solved. So there's a couple of other things with revocations that you should be aware of. In most countries around the world, if you marry and you don't draft the will to express that it's made in contemplation of that marriage, then the marriage will revoke any existing will you have. If you are divorced, in most countries around the world, a divorce will act as a partial revocation of any gift in your will that you've made to the spouse that you've just divorced. None of those rules apply in Thailand. So there's a lot of interchanges that you have to be aware of. You won't pick those sort of things up on the net, because Thai lawyers don't know what the law is as to marriages and divorces in other countries. They only know Thai law. So they're little things that you need to know, or the lawyer needs to know, that you might miss unless you're told otherwise.
All right, let's talk for a bit about what happens when you die without a will.
Without a will.
Without a will.
Okay. In most countries around the world, there are rules of intestacy. That is, who gets your estate in the event that you die without a will. The laws relating to intestacy in most countries have changed over the years as attitudes have changed in society in general. And generally speaking now, the laws in most countries tend to reflect what the will maker or testator would have done had he or she made a will. For example, in most countries, your spouse will pick up most of the estate. Your children might get some depending on the size of the estate. That's pretty well worldwide now, not so in Thailand. That doesn't apply at all in Thailand. Similarly, that's something you really need to bear in mind. In Thailand, the rules as to intestacy are quite different. If you die here without a will, firstly, your wife, if you're married to a woman, or your partner, not your partner, your wife or your husband, that means legal wife or legal husband, doesn't cover de facto relationships. Most other countries around the world, a de facto spouse is placed in the same position as a married spouse. Here, not so. So if you die intestate here, your estate on intestacy will go as to one half of what's called community property, that is, property accumulated during the marriage, to your spouse. The other half will go to, then it will go down the line, it'll go to children plus the spouse to share the other half equally. Then if you have no children or you're not married, it will go up to parents, then it goes down to siblings, and it goes a very complex range of entitlements as to who are these statutory heirs. It's quite complex, and it may go to someone who you don't really want to get those assets. Your testamentary wishes will be ignored. Ultimately, in Thailand, if you can't find any statutory heirs, the estate will go to the government. it's a good idea to have a will in Thailand.
And just briefly, because these people are the ones that are smart enough, that are actually here to listen to all this. But I've heard so many times things like, it really doesn't matter if I have a will because I don't really have anybody I'm close to, or I don't have very much. And so it just seems like a lot of work to go through to create a will. So what do we say to those people?
Well, if you've got a bank account, the banks in most other countries around the world, for example in Australia, if you have up to say $100,000 in a bank account, $100,000 in a bank account, if you give the bank the death certificate and the will, they will release the monies to the beneficiary as long as the beneficiary gives an indemnity to any other valid claim made against the estate. Not in Thailand. The banks hope the hell that your relatives won't bother pursuing their bank account. Now, if you've got 800,000 baht in the bank, that's quite a bit of money to lose, and you might lose it if you don't have a will.
So, and I'll just add to that real quickly. Again, that's not really for these people, but I know all of you, like me, will be talking to the people in your circles, and it'll come up, and people say, "Nah, I don't need a will." And I hope that what you'll talk to them about is even if they are alone, wouldn't they rather have their 800,000 or 400,000 or 100,000 that's in the bank go to a charity than to Bangkok Bank or whatever bank it is? Wouldn't they rather have instructions on how to deal with their funeral and other things that are part of this process? May not be exactly in the will, but part of this process, than they have to deal with it with no instructions whatsoever. So I hope all of us will help the other underrepresented group to understand that whatever time and effort you put into creating a will is going to make life a lot easier for some other folks that you know. So I'll get off my soapbox.
I was speaking to a prospective client yesterday whose father had died here, and he'd made a will in Australia which covered Thai assets as well, and he left his whole of his estate to his son. And I explained to the son, the bank won't release the money unless you go to the court and get a court order. And he had a condo, a cheap condo, which was obviously a bedsitter in Changklan. Oh no, it was just off Tapo Soi 1, and he bought it for 850,000 baht. And he said, "Well, should I go to the trouble of doing it? Should I do nothing?" And I said, "Yeah, you can do nothing if you want to throw $80,000 away." And he said, "No, I'll apply to the court." So there's it's well, in that case, his father had a will, so that was one big plus. Yeah. His father had a Thai partner only recent origin, and I was able to satisfy. He was very pleased to hear that she had no rights whatsoever. She's still in the condo though. We've got that problem to deal with. Yeah.
So let's talk for a minute, hopefully using as much lay terminology as you can, about what the legal requirements are for a will to be valid here in Thailand. So what do we do to avoid that problem where someday in the future when we're no longer here, someone says, "Wow, this is not a valid will"?
There are 5 separate types of wills specified in the Thai Civil and Commercial Code in which you can make a valid will in Thailand. The first is a will made in writing, dated, signed by the testator in the presence of 2 attesting witnesses, with the testator or will maker and the 2 attesting witnesses all signing in the presence of each other. That's a valid will in Thailand. Indeed, it's a valid will around the world. Pretty well every country in the world has that requirement. The second is what's called a holograph will. That is a will made in handwriting by the will maker and dated and signed by him. It doesn't need a witness, but everything has to be in his or her handwriting. In Thailand, I've only seen those 2 types of wills, mainly a will signed in the presence of 2 attesting witnesses, or secondly, on a few occasions I've seen holograph wills. Typically, they have always been made when the will maker's in hospital, probably dying, with a group of grasping relatives telling him or her what they should put in the will. And it normally leads to litigation because it normally revokes the provisions of a long-standing will the testator had previously. So, holograph wills almost always result in litigation. There are 3 other types of wills. A will made before a government official, don't do that. 1, he or she doesn't have a good grasp of English. 2, he or she probably has no knowledge of the law whatsoever. And 3, Thais will always give you an answer. Where's Payup University? It's either there or it's there. It's not I don't know. They will not give you I don't know as an answer.
They say yes on the question.
Yeah, is it there? Yes. Is it there? Yes. Yeah. They won't say I don't know. So you don't do that because we've all been to banks, government offices, land offices, and you might get 6 different answers depending on which county you go to. So it's very unwise. The other 2 remaining types of will is an oral will, can only be made in exceptional circumstances where you can't adopt one of the other formats for a valid will. For example, during war, for example, in the case of imminent death of the testator. You'd almost never see that. And the final thing is a secret will, which is also made before a government officer, but is then wrapped up and held secret until you die. Why you'd want to do that, I don't know. Firstly, you're never going to plaster your will around the town so that everyone sees it. You're only going to give it to people who need to see it. And why have a will made by a government officer who probably doesn't know what they're doing, and then wraps it up to hide the defects in it? So they're the 5 types of will. However, there's a further provision in the Thai Conflict of Laws Act. It says that a will is valid if made by a foreigner, if made in accordance with Thai law, or if made in accordance with the law of nationality of the will maker. So that brings in existing foreign wills. If it's valid in your country and it covers assets in Thailand, it's still valid here, provided it's appropriately drafted. Next.
So tell us maybe 2 or 3 of your best stories about mistakes that people make when they're making their will, or they have someone else make it for them.
Well, again, an elderly testator made a will. He was dying, and he was near death for about 12 months, and he dramatically changed his will to favour a person who was the daughter of a good friend of him, but who acted as his housekeeper. We were able to establish that she had gone to the testator's bank account and drawn money out before his death, and then he made a will with her lawyer, which dramatically changed and cut out his 2 nephews who he had been close to during the whole of his life, and they're the people who he wanted to make provision for. This woman was a thief, there's no doubt about that. Thai law says that if a will's made by a testator and he's a foreigner, then the question of capacity, whether he had testamentary capacity, that is, whether he was capable of making a will, has to be determined in accordance with the law of the country of his nationality. The Thai courts wouldn't accept that. That's their law, and they didn't accept it. Now, that resulted in a nightmare result. We see it all the time, not only wills, purchase of properties. Another area where there's problems where people aren't legally married, de facto spouses have no rights under family law or under the laws as to intestacy if there's no will in Thailand. So this if you wanted to sit down, I'd take you through a series of horror cases about buying properties and people making wills that were dodgy.
Right. And then why don't we spend just a couple minutes on the special circumstances for same-sex couples?
Yeah. Same-sex couples, again, they're not recognised here in Thailand, so they don't they aren't entitled to the normal rights that a partner might have in other countries, where with a same-sex couple, they typically in most countries around the world have the same rights as heterosexual couples who are legally married. There's no difference. Here it's not. So if you're in a same-sex relationship, you have no rights in respect of your partner's property under family law, and you have no rights as a spouse under the law of wills and estates. The same applies to de facto couples. A de facto partner has no rights under family law or under wills and estate law. The Thai cabinet announced just prior to Christmas that they were going to introduce some changes to recognise same-sex relationships and de facto relationships. And they said they would do that by making some simple changes to the Thai Civil and Commercial Code. In most countries around the world, if you're in a de facto relationship, there are a number of hurdles you have to get over to get to the court, to get some rights under family law or under the law of wills and estates. In Australia, you have to be living together for 2 years, or have had a child together, or the person claiming would have to establish that there was an injustice if their rights under the relationship were not recognised. So you've got to be very careful with those sorts of cases. That the law may change. I think they'll make a meal of it. You know, when the Thai government introduced a law a couple of years ago, because all the big liquor companies didn't want these sites selling wine and things online, so they brought in a law making it illegal to sell wine and alcohol online. Well, what the vendors of alcoholic products did is simply put a list of their products and prices and said, we're not allowed to sell them to you online. If you want to email us or phone us, we'll send it. Took them a day to get over it, you know. That's how well the Thai government thinks about things.
So let's also make sure that we don't cause any undue panic here. So what Joe said is obviously absolutely correct, that same-sex partners don't have the same rights. But that really only applies if there is no will. So if you have a same-sex partner and you want them to have certain of your assets, you can absolutely easily do that in your will, and then everything will turn out just the way you want it. The point is that if there is no will, then a same-sex partner will not have the same rights as a married partner if there is no will.
And it's even more acute if, for example, you have you're not married, you're in a de facto relationship with a Thai man or a Thai woman, and they die. The house is in their name. You don't know who's going to get the property if they don't have a will. It's absolutely crucial that if you're in a relationship with a Thai partner and you're not legally married, they need to make a will, providing that if they die before you, they'll leave the property to you. Now, it's an exception to the law against prohibiting foreign ownership in Thailand. You can bequeath a parcel of real estate to a foreigner, but they must deal with it within 1 year. They've got to dispose of it 1 year. Another way around it is for the Thai spouse to make a will saying that her partner can live in the house for the whole of his life. You appoint the partner as an executor so that the title to the property goes in his name as executor, almost no cost at the Land Office, and he can hold it during his lifetime, and then on his death it will pass in accordance with the residuary provisions of the partner's will. So, you know, that's a real hot potato, that one. If you say, oh, you know, I trust her, of course, she won't do the wrong thing by me, but she doesn't make a will in your favour, you may find that her brother and sister are getting all of the estate and they're kicking you out of your house.
This is a point that's so important for so many people that I've talked to, that it bears repeating. So here's the situation. You have a foreigner who has purchased a condo or a house or a piece of land, and while doing that, of course, it has to be in a Thai person's name. So they've got the...
A condo's okay if it's in the foreign-owned quota. That's, yeah.
Right. So this is all fine, and you've got an agreement with your Thai partner or spouse, here's how it's gonna work, and that's all great. The only fly in the ointment is if the Thai partner or spouse dies first, right? And if they die with no will, then as we already discussed, there is a legal formula for who inherits if there's no will. And that will not necessarily be you as the person who bought this property. So again, the key thing here is to make sure you've got the circumstance covered by having your Thai partner or your Thai spouse also have a will that delineates what would happen if that person should die before you do.
Thais generally have an aversion to making wills. They have this cultural belief that it's encouraging death to come forward. That's the way it is. Crazy. All right.
Yes?
I'd try a question if you can. Joe, some of us here have dual nationality. I myself am Australian and British. Under those circumstances, is a will, in my case, made in Australia, valid?
Yes.
Did everyone get that question? We have a person who has dual citizenship in 2 non-Thai countries and was asking the question if he has a will in one of those 2 countries, is it valid here? And the answer is yes.
And that's under the Thai conflict of laws legislation. If you're of foreign nationality, and it can be 2 nationalities if you like, and you make a will in accordance with the law of that country of nationality, it's a valid will in Thailand.
All right, so let's move on. This is one of, I think, the most important conversations, and it's something that is often treated by us lay people as an afterthought, and that is appointing the executor. So we're going to talk today about what is an executor, what's the role, what do they do, why is it important, how should you choose one, right, or more than one. So let's start by just saying, Joe, what is the role of an executor and why are they so important?
There's no word in the Thai language, executor. Doesn't exist. There is a word that is substituted for that, and it's called Pujitkan Moradok, and it translates in English to manager of the estate. It's probably a better word than executor. It more accurately describes the function of the executor. The executor is the person who you have appointed in your will. His or her job, and it can be more than one person if you wish, or you can have alternatives. I appoint A. If she's unable or unwilling to accept the appointment, I appoint B. And they're basically there to instruct the lawyer, if there's a lawyer dealing with the probate application. Hopefully you will have provided the executor not only with a copy of the will, but advice as to where the will is. You'll also provide him with an updated copy of a list of your assets and debts, where they are, what's the contact, what's the passwords, all of those things that they need to know. It shouldn't be in the will, but it should be kept with the will and kept up to date all the time. And the role of the executor normally is only to liaise with the lawyer who's dealing with the estate. The lawyer will know what to do, and the more work that you do as a testator or will maker, and the more accurate the information you give your executor, the less work the lawyer will have to do, and therefore the less costs will be incurred in managing the estate. There are really only 2 qualifications for an executor. 1, they have to survive you. 2, you have to trust them. Okay, so you need, there's an...
Talk a little bit about why you have to trust them. What bad thing could they do?
They could put the whole of the estate on a racehorse. They could gamble away your estate, for example.
Yeah, the executor has the keys.
Nothing in a will stop a dishonest executor from stealing money from you.
And they can do it in lots of ways. 1, they could invest in a racehorse. Two, they could generate a lot of expenses, because one of the things your will say is that it will allocate funds for the executor to do his or her job, right? And so an unscrupulous executor can have that be a very expensive process. And you want to trust the person.
They are already under a legal obligation to act in your best interests and in the interest of your testamentary wishes expressed in your will. They have a legal obligation to do that, but you've got to catch them doing the wrong thing, or someone's got to catch them doing the wrong thing. So you need someone you can trust. Do we want to deal with what estates now, what happens in the event of death?
No, maybe not yet.
Okay, righto.
All right, so I think that's a good segue into this last point, which is the importance of, an executor really should not find out they're your executor upon your death. I mean, you should have the discussion with them, so they know, as Joe said, they know where everything is. Nothing is a surprise. They know what's expected, and it is not it's not a terribly difficult discussion to have, and it is something though that is very important to have. Because certainly, we all could possibly know someone who meets the criteria who just has no interest in doing it. And that's not really fair to burden someone if they have no interest in doing it. So having a discussion ahead of time with someone that you're thinking about being an executor is probably always a really good idea.
There's an additional consideration in Thailand as to the appointment of an executor. Unlike almost everywhere else in the Western world, an application for probate or administration in the case of an intestate estate is done by the court on the papers and signed by a registrar of the court in his chambers. That is, no lawyer, other than to file the documents, no lawyer has to go to court and appear on your behalf. It's relatively straightforward, it's relatively simple. The court requires the executor to file what's called an oath of office. That is, I swear that I will administer the estate in accordance with the law and in accordance with the will. And the court accepts that. In some countries, Australia being one of them, randomly they will pick estates and require the executor to file accounts. That is to file a document setting out what monies have come in, what monies have gone out, and show that he properly administered the estate. In Thailand, you've actually got to go to court. The executor has to appear in court and give evidence, and the judge has to be satisfied that he's an appropriate person. Crazy. That doesn't happen anywhere else in the world. During COVID, all court applications on probate and administration stopped. And then when it kept going, they decided, we'll hear these matters by way of Zoom. So we then started hearing estates by way of Zoom, worked perfectly. Then COVID finished, so they went back, you had to go to court. Crazy, can't believe it. But not only do you have to go to court, the Thai Civil and Commercial Code provides that your estate, the statutory heirs on intestacy, the statutory heirs are entitled to your estate as specified in the legislation, but if you have a will, the beneficiaries, in the Thai legislation it's called legatees, but it means beneficiaries, are entitled to the estate. The Thai courts, however, require you to file a family tree, starting with the deceased parents. Then you have to prove the deceased was their child, birth certificate, death certificates for the parents. Then we have to look at the other statutory heirs. Was he married? Was he divorced? Need marriage certificate, divorce order. Then we have, were there children? Details of the birth children, who were the parents. And then if one of the children die, in the legislation there's a per stirpes provision that if one child dies having a child still alive, that child takes the parent's share. The court requires you to file a family tree, and every one of the statutory heirs, every person who would have been entitled on intestacy has to file a consent. Why in the hell that is required, I have absolutely no idea. Because the law itself says the beneficiaries, if there's a will, the beneficiaries are entitled. The statutory heirs have nothing to do with. I guess the answer is TIT. This is Thailand. Yeah.
So that's a good segue into a discussion of probate. So probate kind of seems to get not as much attention in these discussions because everyone's concerned about having a will, and gee, I got a will, so everything's cool. And so it doesn't come into play until after the will becomes effective, which is after we die. But probate is unlike, and Joe will get into this more detail, but probate for a lot of the states is not a big deal in other countries. Here, virtually every estate has to go before a judge, and Joe will talk about that. So that, as he just mentioned, this family tree, or this tree is one example that I mean that kind of blindsided me when I was looking at this, because I got thinking, so as Joe said, in my probate I would have to show the birth and or death certificates of my parents. Well, right now as I sit here, I have no idea even how to do that, right? I know it's doable and I will have to do it, but it's sure better to know it now than for some executor of mine to be surprised and find out later and have no idea perhaps even what my mother's maiden name was, right? Which would make it a problem to get her birth certificate. So at any rate, we're going to, and by the way, this process can also be, if not managed properly, can also be a financial black hole, because if your lawyer doesn't really know a lot of the answers to these questions, then there's going to be a lot of spinning wheels, and spinning wheels when you've got a lawyer means a spinning money machine, right? And so you really want to make sure that you understand the requirements of probate so that you can do this last point, which is to prepare to save time and money through the process, right? So Joe, why don't you talk about what probate is here and why it's so important?
Yeah, lawyers make money out of probate applications. I regard my job as giving clients advice so they can avoid those costs. That's part of my job. You're telling me do the right thing by me, do what's best for me, and my job is to make sure, if at all possible, that you don't go to the expense of having to go to a court. If you have a bank account, the bank won't release it without a court order. If you own a car, the motor registry won't transfer ownership unless you have a court order. If you own a condo and it's within the foreign quota, so the testator owns it, the land office won't transfer it unless there's a court order. All of those things apply. And on each occasion, the executor might have to come back to Thailand. So the executor may have to come to Thailand a few times. That's all cost. There are ways you can manage your affairs to ensure that that doesn't happen. I'll give you one clue. Your bank doesn't know when you die. Okay? So there are ways by planning in advance that you potentially can get out of having to get a court order. I'm not going to go through them chapter and verse with you now because I don't want people complaining about what I say. But if I make a will leaving my estate to my wife, and my wife is able to access my account when I'm dying, or maybe very shortly after my death, and she's legally and morally entitled to it, I don't see a problem with that. I'm happy to discuss those arrangements with anyone personally, but I'm not prepared to do it in an open forum. But sure, that's something you should definitely look at, because it will cost you probably to write an application to court where there actually has to be a court appearance and evidence given. And believe it or not, a probate application, the court won't issue the order for a month after the order's made so that the appeal time can elapse. God help us, an appeal against a probate order, So your executive might have to go to court and then might have to come back to close the bank account. It's just crazy. It shouldn't be happening in this modern world, but it's happening here in Thailand. So there's ways around it. Happy to discuss them with you if you wish me to. If you have another good lawyer, by all means, we're not saying come to us, but I'm saying you should look at these issues carefully.
Yeah, and that's a question. Questions about probate should need to be asked as you're preparing the will, so that if you're an informed consumer here, you can ask, you know, what are the things I can do to make my will be appropriate for as long as possible. Joe's told me the stories about, so if I put all my assets in the will and then I live for 20 more years and now my list of assets is different, so my will has to be substantively changed any time there is a significant change to the things I own. So you can avoid that if you prepare your will properly the first time. Same thing with probate. Ask the questions while you're talking to a lawyer about doing the will. What can we do to streamline this process or to avoid the court hearing altogether? So again, the more time and effort we put into it up front, the better off we'll be. I saw a hand back there. Yes?
Yeah, so if you have a will and you specify how your bank account is to be disposed, you still have to have this family tree for probate.
Absolutely. It's crazy. Yeah.
Absolutely.
Yeah.
For all probate.
Excuse me, but what is probate?
Probate is an order made by a court approving the will, or proving it, sometimes that word's used, and appointing an executor to manage the estate. Administration, I'm talking Western country language now, US, UK, Australia, Canada. Administration, or it used to be called letters of administration, is in cases where there is no will. That is, there's an intestacy. The deceased died without having made a valid will.
I actually think we've covered all three of these issues, so I'm going to move on. And we're coming up on break time, and then when we come back, we'll have plenty of time for questions. So I think we're pretty much right on schedule. All right. Joe has probably told me 52 times, I don't know why you keep using this word trust. There's no such word as trust in the Thai law. So Joe's going to explain, instead of trust, what do they do here and what potential value can it be to you. So we'll spend just a couple minutes on that.
Trusts are not recognised under Thai law. I assume the reason for that is that it encourages people to have nominees. A trust is where the legal owner and the beneficial owner are separate entities. I buy a property in my name. I'm Thai. I enter into a trust agreement with you and I say, I hold the property in trust for you. At any time you can require me to transfer the property to you, you being a foreigner. Now that's illegal in Thailand, but they also ban trusts. It appears in a number of Thai entities that really are trusts. One is the usufruct. Usufruct is from European civil law, and it comes from the Latin words usos, use of, fructos, fruit. Use of the fruit. That's a trust. A usufruct can be in respect of an interest in land, and it can be for the life of the usufructuary. Sounds like beneficiary, doesn't it? Life of the usufructuary, or a term of up to 30 years. And it can be, the Thai law says, it can be granted for no consideration, and you don't have to be married or in a relationship with the person you're granting the usufruct. The land officers don't have the same view, notwithstanding the law says something different. Another area where Thai doesn't recognise trust, so where you make a bequest to an infant child, I give the rest and residue of my estate to such of my grandchildren as shall survive me, and attain the age of 20 years and have more than one and equal shares. Okay? Who holds the asset until the child reaches that age? The trustee in any normal will. So in Thailand they had a problem there. So what do we call the person who holds the property on behalf of the children? We call him controller of property. And that's what Thai law says. It's a trust.
Thank you. All right, so now we hopefully we've convinced anyone that needed to be convincing. You probably ought to have a will, and even though it's conceivable you could do your own will, you probably want to get someone who knows what they're doing. So how, Joe, do you find the lawyer that's good for one's own particular circumstances?
Okay. Contrary to what you'll see on the internet, your will doesn't have to be in Thai language. We do wills in English where there's no Thai involved, and we do wills in English and Thai where a Thai is involved, say a Thai wife or a Thai beneficiary. The will typically says if there's any dispute between the meaning of the Thai version and the English version, then the English version prevails. We're not saying English law prevails. We are saying that looking at the words, we choose the English word if there's any dispute between the two. For example, English is a much more precise language than Thai. And Thai, I'll give you an example. The word lan in Thai can mean grandson, granddaughter, niece or nephew. Bit of a problem if you're relying on a Thai document that says lan. So that's the situation there. How do you find a lawyer? What? Assuming you're an expat, you need a lawyer. Doesn't have to be a foreigner, but you need a lawyer who can speak good English and who can make him or herself clear in what he's telling you. You need someone who doesn't have... I'll give you an example. In wills I do in Thailand, the Thai courts like a clause saying, I am sound of mind. Now, it's got me... I can't understand how you can be sound of mind because you say you are. I don't get it. You know, it's pulling yourself up by your bootstraps. You'll also find in a Thai will, I make this will voluntarily without duress or undue influence. Again, it's the person who's suffering duress or undue influence who will say that because he's told to say it. So you need someone who is attuned to the cultural problems with Thailand. You need, and we always do this, whenever a Thai is involved in the will making process, I'm not a Thai lawyer. I have one of my Thai lawyers sit in with me so that he or she can explain to the Thai person precisely what we're talking about, what is planned, why is it planned that way, and then you need to get the will beforehand. You need to go through it carefully, make sure there's no mistakes, make sure it fits in with your wishes. So you need someone who can deal with you as a foreigner, and you need someone also there who can explain to your Thai partner, assuming you have one, exactly what's happening. And you'll find in that case the Thai partner is likely to be to go along with what is planned after he or she understands precisely why it's being done. That's the sort of person you need. It doesn't necessarily have to be Lana lawyers, but boy, it has to be someone who knows what they're doing. And one of the problems in Thailand is that law is not taught in English, it's taught in Thai. We have the cultural problem in Thailand where critical thinking is not part of the Thai personality, and it comes through the education system, and they don't want to make waves, they don't want to question the teacher, and they carry that into their adult life. Some of the better universities in Bangkok have a first year compulsory subject, critical analysis or critical thinking, so that people can learn to think critically. What are the problems? What do we do here? How do we get around the problems? So that's the sort of person you need, not someone... Some of my lawyers, when I first came to Lana Lawyers, I'd say, what do we do here? The answer was, we do this. Why do we do that? Because that's what we always do. And I would say to them, there's two there who've heard me say this many times, you go and find out and come and tell me, convince me why we're doing it that way. And often they'll come back and say, well, it's not in the law, but the courts want this. And we have to just wear that, unfortunately.
All right, this last point, and then we'll get you on a break. Like any other activity with a lawyer, and my background is in business, so I've dealt with a lot of lawyers on international, domestic, personal property, intellectual property, lots of lawyers about lots of things. And one of the lessons I've learned is the more organized I am in terms of understanding what I'm trying to accomplish, and the better I can communicate that to the lawyer, and the more I have my information together. the better my lawyer understands what we're trying to accomplish. B, the less time it takes the lawyer to figure out what I'm trying to accomplish. And then that leads to C, which is less time equals less billable hours. So the things that you're learning through this 4-part series, hopefully, a big chunk of it will be, how do I get organized to understand what I really want, so that when I sit down with a potential attorney, A, I'll be able to ask the kind of questions that'll indicate, my degree of confidence that this person knows what they're doing, and B, that they will be able to get the best result with the least amount of billable hours. So with that, we're going to take a break. We're going to, let's try to limit it to not more than 10 minutes, and we're probably going to be 10 minutes late leaving here. It'll probably be 10 after to make, because I don't want to cut off questions. So go do what you need to do, get back here, let's get started and have a good Q&A. How many people would be interested in having a 5th session, totally free, and it's an hour and a half of Q&A, and it'll be, it would also include the topics coming up in the next 2 weeks, so the living wills, healthcare, and then kind of all the details after it's all over. So show of hands, how many people? I'd say we have a quorum. All right. So I will, officially, I will have to check to make sure the room is available. But let's assume that I will indeed check on that, and it will indeed happen. So if you have to leave before your question is answered, or if we don't get to all the questions today, there will be ample time to do it. We'll have a separate session totally for questions. And with that, let's go ahead and start. So I've asked Joe to A, hold the microphone closer while he's doing this, and B, to keep these answers almost at the risk of being too short, to have them be short so we can get through as many as possible.
Okay.
Also, one more thing, could I have Colleen, maybe you could come down here and distribute some of these pieces of paper like we did last week. And again, to repeat, we will be emailing the slides to everybody at the email address they used when they signed up. Okay. We have lots of questions about the family tree, and that's probably my fault for bringing that up. It's a complicated thing, and that one I'm gonna leave until the final, because it's kind of a rabbit hole to go down, and I'm afraid we're gonna do 15 minutes on the family tree. It doesn't deserve that.
With family trees, there is a very simple, cheap system on the web, Family Search, which is based in the US, which is very good at doing that.
Right. So I got the answer from this gentleman here is that there is an app for that, for doing this family tree. I will get the information about that and make sure it's disseminated.
But it needs to fit in with the Thai laws as to intestacy, because a normal family tree won't pick up the appropriate statutory heirs.
I've got three family tree questions right in a row here, so I clearly opened up Pandora's box.
With the materials you will receive by email, there's an article headed Who Takes on Intestacy, I think. But that goes through in some detail how the statutory heirs can be identified.
So it sounds like we've got we'll have to devote a good 10 or 15 minutes to family trees when we do this auxiliary session. Another one.
What I might do is to put a couple of samples up on next week.
All right, good idea. Here's a good question. Can your lawyer be your executor? And then can you establish the price for those services up front? I think many lawyers will tell you that they prefer not to be the executor, and I think Joe is one of those.
I think there can be an inherent conflict of interest there. And also, if you can find someone that you trust as a friend, you're not going to get all those billable hours doing, this particular work. So, and then finally, I think it would be very, very, very rare for a lawyer to give you an upfront price on being an executor, because, again, you might live 20 more years and the requirements could change significantly between today when you do your will and tomorrow when it becomes effective. So I hope that answers the question.
Yeah, the firms I've worked with have had a general rule that we don't accept appointment as executors because it puts you in an impossible situation. We have been prepared to make exceptions. A little old lady who has absolutely no one. I used to have a client who come in and change her will all the time. The Cream Wireless went to 5 different beneficiaries at different times, I think, but we didn't charge her for those wills. But yeah, it's not a good thing to accept appointment as
There was a question about.
and I'm told.
There was a question about handling funeral arrangements and cremations and things, and that we will discuss in a lot of detail over the next 2 weeks. So that would be patient.
Was it discussed, is it recommended or not recommended your spouse be the executor?
Yes, provided she has the capacity to do so. That is, she has the wherewithal to understand what's required. Normally she'll be guided by the lawyer. She doesn't have to do much really, but she has to have, be prepared to take it on.
So here's a question that we sort of covered. Can one write their own will, have it witnessed by 2, and registered at their ampur?
Yes, you can do your own. You can have it witnessed by 2. Everyone has to sign in the sight and presence of each other. Do not give it to the ampur.
I take it that's a soft no.
Why would you give it to the bloody ampur? I just don't understand it. It can't be registered. It's give it to the executor and leave a copy with your lawyer.
Yes.
Forgive the indelicacy of this question, but as my lawyer, what happens if you predecease me?
Sorry.
I couldn't help but notice that you are not a spring chicken.
Yeah, no, that's what I said. If I don't encourage, for the very good reason, I don't encourage appointment as an executor because I might die before you.
But what happens? You are my lawyer.
Oh, your will is not invalid simply because the executor dies. Someone else can apply to be appointed.
So who do I talk to?
Oh, a person with appropriate standing, a relative or a.
We're talking about the lawyer. If your lawyer dies.
Oh, your lawyer dies.
Yeah.
Your will's still valid. You've got an original of it.
But my lawyer is my lawyer.
Oh, well.
Who do I talk to if there's no Joe?
Noon, who's gone now, but Noon's capable of dealing with that. Yeah. Have a look at our website. We've got at least 6 Thai lawyers.
And they are principals.
They're licensed lawyers.
And are they principals?
Only Predar is. I've never seen him do a will. But he has been executor on occasion.
There's a question about how do executors get compensated in Thailand, and it is that will be discussed in your will to some extent. Often it is just something as simple as normal and customary charges.
Yeah, we have a standard clause that says if you appoint one of our lawyers as executor, work that they do as executor will be charged out on the basis of time spent at our normal rates.
Interesting question. Are class action lawsuits null and void following death of a claimant?
I don't know. I wouldn't think they would be. You just put a new head plaintiff, lead plaintiff. You just move someone up.
Yeah.
Yeah, move someone up in the list of possible claimants.
Yes,
Do we
Ivan.
need to prepare for the death documents of the parents?
Yeah, that's that family tree discussion.
Can you
And-
repeat the
All right,
question?
she's asking if you need to have the family tree documentation done ahead of time. And my answer is, there have been so many questions about that Pandora's box that I'm responsible for opening, that we're going to make sure we discuss that in detail at this auxiliary discussion. We'll just.
The short answer is, it's a good idea to collect the information. Don't do a family tree because people may die.
There you go. Yes.
Can you say exactly what information is required?
Sorry?
Can you tell us exactly what information is required? You need your parents' birth certificates.
That's the best evidence, but the courts aren't real.
Repeat the question.
All right, so once again, I'm going to just shut it down. So, sorry. This is it's a 20-minute discussion about this family tree. It probably doesn't merit that, but because of the way that I opened it up, it sounds like it's a really big deal. So we're going to discuss it in the appropriate amount of detail at the ancillary Q&A session, and not today, because we just got it. I don't want to keep people past the time. Have the mic. This is right there. That is a document I got from Joe about the family tree. So that's the kind of information we're asking. But again, we'll get into that in more detail.
That's
Okay.
anonymised, by the way. It's not a real document.
I have the mic. Can I ask a question?
Yes, Keith.
For somebody who has the $800,000 in a bank account, for whom it's not practical for the beneficiary to transfer it out themselves, what involvement with somebody, if the heir is from, say, the U.S., would she have to come to Thailand physically to effectively get that money, or how would that work?
The executor would.
If she were of the executor of the Thai will.
We could talk about having someone appointed as a power of attorney of the beneficiary. It's the executor who empties the bank account. It's not the beneficiary.
Okay, thank you.
Yes, sir.
You mentioned before about when preparing legal documents that you can specify that the English version takes precedence. This is not my experience.
Well, it is mine, and it's every reasonable firm who does expats work.
All right, so the question, it had been raised by Joe in his comments earlier that you can say that in a conflict of language that the English version will take precedence. And so this gentleman was saying that in his experience with issues other than wills, that is not the case, that the English language would take precedence. So he's asking for a clarification.
Okay, every document we do, whether it be a will or a contract or whatever, a divorce agreement, whatever, has the same clause. We're not specifying English law. We're only dealing with the question of what language is to be used. Any contract could have that. You can do a document in Japanese and Thai, and you can say, insofar as language is concerned, the Japanese will prevail. You're not interfering with Thai law. You're saying if there's a fight, then it's under Thai law. We're only talking about interpretation of the words.
Back left. Just a general question, Joe. Is it beneficial at all for the probate process to have a like a certificate of competence for the testor? So a medical certificate or a doctor's letter?
No, there's a presumption that he was competent. If I have any doubt with any testator, I get a doctor to have a word with them. I remember I was honorary lawyer for an old people's home earlier in my working life, and I went up to the home, and there was the man there with the nun, and he had no nose. His nose was missing, and he couldn't explain to me what. And the nun's saying he wants to leave it all to the home. And I said, Sister, I think he'll have to have a talk with Dr. Malani first. They're easy to pick, in my view, if they don't have capacity, and you get a doctor's.
Colleen?
I had heard that you have to have a same amount of work time, the same day that you write the will, is that true?
That's wrong.
You don't need that.
No. If there's any doubt, I would absolutely get a doctor. But you don't know, it's not a requirement.
And one more thing, what is your per hour rate?
5,000 baht an hour. If we've got a Thai lawyer and an English-speaking lawyer working on the same matter, we charge for only one person. Where we can, we will reduce the fee to a flat fee. As soon as it's only matters where you, like litigation, how long is a piece of string, you never know. But if we can reduce it to a fixed fee, we'll do it.
Any other questions for this session? Right here? Yep.
I'm just curious, being an American, I collect Social Security. I also have a pension. How do you instruct them to stop paying?
And I actually know this answer for the U.S., and that is when a U.S. citizen does, and I think it's other nationalities as well, the part of the process is to inform your consulate or your embassy, and the embassy, because the U.S. government has an interest in not continuing to pay your Social Security, that they will in fact do that notification. If by some chance they don't, or you're in a jurisdiction where it doesn't automatically happen, then there are instructions. There will be instructions, for example, on the Social Security website on how to do that notification.
Speaking for Australia, the Australian Embassy will make sure no further pension is paid if you die.
Funny how good they are when they money involved for them. Okay, anybody else? Next week, living wills. Next week, healthcare. 2 weeks from now, the kind of what happens when the time comes. All the details, the passwords, the documents, just all the millions of details. So that's what's coming up. We will now, I'll go to work on adding that 5th free session on more Q&A. I'm real happy that you all came. Thank you very much. Happy for the feedback. Don't forget media@chiangmaiexpatsclub.com if you've got questions or comments or have want to discuss those topics I raised at the beginning of the show. Thank you again for coming. See you next week.